New developments today in the federal documents indictment of former President Donald Trump. This morning, the magistrate overseeing the case ordering Mr. Trump's attorneys not to share evidence with the media and the public, and notably saying the former president cannot retain copies of the documents and must have supervision while reviewing all material. The order, coming as Trump's former Attorney General Bill Barr escalated his attacks on his former boss in these scathing comments. Take a listen.
He will always put his own interests and gratifying his own ego ahead of everything else, including the country's interests. There's no question about it. This is a perfect example of that. He's like, he's like a defiant 9-year-old kid who's always pushing the glass toward the edge of the table, defying his parents to stop him from doing it. It's a means of self-assertion and exerting his dominance over other people. And he's a very petty individual who will always put his interests ahead of the country's, his personal gratification of his, of his ego. But our country can't be a therapy session for, a troubled man like this.
And joining us now, NBC News justice and intelligence correspondent Ken Dilanian, Boston Globe columnist Kimberly Atkins-Storr, Bulwark editor-at-large Charlie Sykes, and NBC legal analyst Danny Cevallos, also former prosecutor David Henderson. I thank you all for being with us. So, Ken, bring us up to speed on the new instructions from the U.S. magistrate in this court.
Hello, Jose. This is called a Rule 16 protective order. It's absolutely standard and pro forma in a situation like this. But this, of course, is getting a lot of attention because there's nothing standard and pro forma about former President Donald Trump as a defendant. We know he has a habit of making public information that he learns from his lawyers in various legal proceedings. And so this order makes very clear he's not allowed to do that. Nobody who gets access to discovery materials in this case is allowed to release them to the news media. And what that means is that's the names of the witnesses and the nature of their testimony, which is significant because people who end up being witnesses against Donald Trump often find themselves on the receiving end of death threats. And as you mentioned, it specifically restricts Donald Trump from retaining copies of any of this material. He's allowed to take notes on it, but those notes must be stored with his defense lawyer. So a lot is riding on the defense lawyers and their ability to supervise their client. Just to be clear, this applies to the non-classified discovery information. The classified information, that will come under a whole separate set of complicated procedures. His lawyers are going to have to get security clearances. We know the government intends to introduce 31 documents. It's not clear whether any of those have been declassified. There are certain procedures that allow the government to not show the jury the full portion of the documents, but you can be sure that Donald Trump and his lawyers are going to be pushing the government to get access to every bit of all the classified information seized in this case, and that's going to be an ongoing dispute in this matter, Jose.